In the 1980s, the Southern Poverty Law Center cemented its legacy by doing the unthinkable. It successfully sued and bankrupted the Ku Klux Klan. For decades, they were the undisputed gold standard of civil rights litigation. But 40 years later, a federal grand jury in Alabama has returned a staggering indictment. It alleges that this same anti-hate organization has been writing six-figure checks to the imperial wizard of that exact same Klan outfit. The Department of Justice filed a level-count indictment against the group, charging the nonprofit with wire fraud, making false statements to federally insured banks, and conspiracy to commit money laundering. Between 2014 and 2023, the indictment claims the SPLC funneled more than $3 million in donor funds directly to the leaders of violent white supremacist and extremist groups. According to the DOJ, the organization engineered a covert network of shell companies specifically to hide where this money was going. The case raises a central question. How does a storied civil rights charity end up operating with the financial mechanics of a dark money syndicate? The SPLC operates as a financial powerhouse, controlling an endowment of more than $800 million. This financial audit shows how that wealth is managed. Over $170 million are held in complex alternative assets and private equity funds, rather than traditional stocks or bonds. These records also show the geographic reach of that capital, with millions of dollars routed to accounts in notorious tax havens like Bermuda and the Cayman Islands. While offshore investing is legal for large nonprofits, it indicates an internal culture of financial opacity. The organization was already experienced in routing money through complex, multi-layered structures long before they began the domestic operations cited in the indictment. That same mechanical complexity was allegedly used to move donor money into the hands of extremists for nearly a decade. The DOJ's case focuses on shell companies, entities that exist only on paper to move funds without triggering bank alerts. Let's trace how this worked, starting with a standard donation to the charity. The organization allegedly diverted those funds into bank accounts for fabricated businesses with harmless names like Fox Photography, Rare Books Warehouse, and the Center Investigative Agency. To further wash the paper trail, the money was moved into a secondary, unmarked bank account. Finally, the funds were loaded onto untraceable prepaid debit cards. The charity labeled the recipients field sources, but the DOJ identifies them as high-ranking neo-Nazi organizers, Klan leaders, and the architects of the 2017 Unite the Right rally in Charlottesville. Through this specific architecture of shell companies and wash accounts, money intended to fight white supremacy ended up directly funding its leaders. The SPLC maintains that these payments were part of a legitimate intelligence-gathering operation. They argue these extremists were simply paid informants used to infiltrate and monitor dangerous hate groups. The DOJ's counterargument is that the intent of the program does not excuse the method of the payments. Using fabricated businesses to systematically deceive federally insured banks and misrepresenting the use of funds to donors constitutes a criminal fraud operation. The indictment doesn't target the act of paying informants. It targets the deliberate use of shell companies and fake names to deceive the financial system. The SPLC vowed to fight the charges in court, characterizing the entire prosecution as political retaliation. However, former federal prosecutors note that setting up dummy corporations specifically to bypass banking oversight fits the legal requirements for the crimes listed in the indictment. Ultimately, this case reveals a significant gap between the public mission of major charities and their behind-the-scenes financial realities. When a civil rights watchdog utilizes the same obfuscation tactics as the organizations it monitors, relying on offshore havens and shell companies, the line between an intelligence operation and financial fraud begins to blur. The courts will now have to decide where that line ends.